So, 14 years ago, while at the ICC, the Citizen TV captured a story where Katwa Kigen was required to actually submit a statement. So, allow us in this particular episode, ladies and gentlemen, to take you back to 14 years ago when we're detailing the aspirations and the rise of Katwa Kigen before we come back to what has happened in just less than 2 months. So, 14 years ago, this is what happened at the ICC.
The prosecution had raised concerns given that Kigen's move to give a witness a prepared statement was against the rules of the International Criminal Court, attracting a stern warning from presiding judge Ekaterina Trendafilova to Murray not to submit any statement that he had not drafted personally.
The chamber requests you not to make any written statement nor to sign any written statement prepared by someone else related to the current case where you kindly appeared as a witness.
And also reminding all lawyers not to act in such a manner when preparing their witnesses. Presiding Judge Ekaterina Trendafilova ordered Kigen to submit copies of the two statements, one that the witness had handwritten and the second one that he had drafted as a lawyer.
The statement I would have to have kept it. The statement was recorded in my presence by another counsel, who actually is a judge in Kenya now.
Yes, so as soon as possible.
Yes, madam.
So 14 years ago, there were two statements that a witness for President William Ruto had actually recorded. This was part of the ICC case that was going on at The Hague, Netherlands, which of course found President William Ruto and the former President Uhuru Kenyatta not guilty on the allegations that were being raised against them. Okay, the actual truth is that there was no sufficient evidence, so then the case was dropped. So on the guilt or otherwise, we assume that because there was no sufficient evidence, then the two presidents were not guilty. But then the court's pronouncement was that there was no sufficient evidence. So let's not read into it beyond that. Now, what was happening is that there was a witness that appeared before the ICC, and there were two statements. There was the statement that the witness had handwritten himself, and there was also another statement that Kigen had recorded as a lawyer. Now, at the ICC level, the judge, Katerina, wanted the statement that the witness had written and also wanted the statement that Kigen had recorded, because the statement that Kigen had recorded is the one that was presented and the statement that the witness had written was not there. Now, I'm setting you at a point that will depict to you who is lawyer Katwa Kigen and what is his relationship with the state thus far. So from as early as 14 years ago, Kigen has been in the forefront of fighting for the interest of Kenyans who are facing charges abroad, and one of the Kenyans who was facing charges abroad happened to have been President William Ruto currently and the former President Uhuru Kenyatta. Now, away from that part, the second time we are witnessing a very key involvement of Kigen is during the Eric Mutai impeachment. You remember when the governor of Kericho County was supposed to be impeached? Now, the lawyer that came to save the governor of Kericho County was Katwa Kigen. So before we go more into his being nominated as AC and also the interview that before the Court of Appeal, or before the JSC that gave him the position as a judge of the Court of Appeal, and his current interest right now in the Supreme Court, let us go back to the case of Eric Mutai and see something.
Is that indeed in our response both in September 2024 and in this time round, we explained and provided lists of youths and women who are paid on those projects. We are aware that similarly the County Assembly, through the committee that purported to investigate, came with a list of youths and women. And our position is that there is nobody owed, and if there is any amount that is owed, they should go to those contractors. But significantly related to that allegation that there are some people who have been deprived of their due payment, it is our contention that the Senate is not a forum for their claim for labor rights. If they had any complaint about their rights for work done, they should have gone to labor court or should have reported to the police or even gone to civil court. And to that extent, therefore, Honorable Senators and Mr. Speaker, sir, we are contending that the issue of Kasim Tani as a ground for impeachment is a red herring. The issue of Londiani accident, we already explained, and I would like to explain again, that it was the committee and the activities of that committee were in the hands of central government. They were not in the hands of the county government. And the person who was chairing those proceedings was the county commissioner. The signatories to the accounts was the county commissioner and members of those committees. And Mr. Speaker, sir, when I asked the question to the past the witness who came to bring that issue, he admitted that indeed the governor did not sit in that committee, was not a signatory to that those accounts, and there is nowhere where he is associated with those funds. System was verifiable. The second thing that they are all agreed on the other thing that the witness agreed on is that indeed the records of the county assembly contain details of the payroll and ID numbers for the various MCAs, and that if somebody was determined to get them, especially within the establishment of the county assembly, they could get them. With us, in that context, therefore, it is our contention that indeed it was possible for somebody else to vote, and that the three experts admit that if you get those credentials, you could vote. So that there are those two admissions, Mr. Speaker, sir, and honorable senators. Number one, that with the credentials, anybody could have voted for those MCAs, and number two, that they are not able to trace back those three votes to the three MCAs. Now, the last thing I wish to say, as I spare a few minutes for my client, is that we would like, honorable senators and Mr. Speaker, sir, that you take on board these as you consider the propriety of that system that was used to vote. Number one, we pointed out in the course of testimony that indeed the answer has been edited. It has been edited so that it is not consistent with the audio recording of the events. Number two, it is true that a few minutes before the movement of the motion on 6th of August, by the mover of motion, who, as we cross-examined him, we maintain is in collusion with the Speaker, 6 MCAs, there was an attempt to remove 6 MCAs with a view to reducing the numbers or otherwise to intimidate them to support the impeachment of the governor. Number three, is the
now just a bit we stretch the video a bit to just give you a little bit show of Man Kigen in action. And senior counsel Katwa Kigen is actually an individual that is stellar in his area of practice. Actually, he's among the colleagues who was alongside Honorable President William Ruto in the ICC case, and he was among the lawyers that actually defended that case to the end. In that case was of course also another guy called Honorable Wakili Joel Bosek, who is actually a senior as well. So there are two individuals whose prowess in the game is unmatched. They're actually very well skilled, and as also a junior within the profession, there are people that I look up to when it comes to their prowess in knowledge of the law. But knowledge of the law aside, there is always the other aspect of the law called the business of the law, and Katwa Kigen seems to really understand both the knowledge of the law and the business of the law so well, because after winning that particular case where we were just playing for you a little bit of Kigen in action, around 2 months ago, this senior counsel who was also now, who is a current senior counsel now, but who was formerly just a counsel for President William Ruto, received the conferment of senior counsel by President William Ruto. So I'm just going to play a little bit news bite on when it's being called and is being conferred. You can find this video online to build up on the story of what we are talking about on Kigen's interest of becoming the next Supreme Court judge.
You know, since 1990, Joseph Kipchumba Kigen Katwa.
Joseph Kipchumba Kigen Katwa has practiced at all levels of Kenya courts and tribunals since 1996. These include land dispute tribunals, arbitrations, commissions, and others. His National Land Commission and many others. Magistrate High Court, Court of Kenya, Court of Appeal Kenya, and Supreme Court of Kenya. He has also practiced at East Africa Court of Justice, sitting at Arusha, Republic of Tanzania, and International Criminal Court, ICC, at The Hague, the Netherlands, and at the IAAF Sports Law, sitting in London, United Kingdom.
Right, then he goes ahead, then he receives that particular accolade from President William Ruto, and is now conferred the rank and dignity of senior counsel. Now, this happened just around 2 months ago. Katwa Kigen had come from the lawyer that defended President William Ruto 14 years ago, to the lawyer that saved the governor of Kericho County from impeachment, to the lawyer that was being conferred the rank and dignity of senior counsel shortly before he appeared in this particular interview. Now, in this interview, Katwa Kigen wanted to become the next Court of Appeal judge. These interviews were just concluded the other day, where a lot of judges were actually shortlisted for the interview, and Katwa Kigen was among the individuals that got picked to become the current judge of the Court of Appeal in Kenya. He's supposed to even be undergoing training right now, so let's just go a little bit again on that particular bit of him appearing before the interviews, and then now we will close with the Supreme Court position to build up on this story that we have stayed on for a while.
Counsel, Attorney General and Commissioner.
Thank you very much. Thank you.
Yes, thank you for that introduction.
Who is competent, who is diligent, who is disciplined, and who is competent. Yes, and one who is ethical. Yes. Thank you, Chief Justice.
Thank you, Honorable Chief Justice. Mr. Katwa, a few questions from me.
Yes.
It's been long since I last saw you making your maiden appearance in the then Court of Appeal in Nakuru.
Yes.
And it's like, it's been many years, and you really traveled the world, as it were. Now, you are endeavoring to join the Court of Appeal, and I can tell you that it is not so rosy on this side. And I would like us to focus on Article 168 of the Constitution. Article 168(1) that makes provision as regards the removal of a judge. I'm more interested in the last two. That is, a judge can be removed on account of incompetence and for gross misconduct. So there are competing interests. A judge says, I'm independent, do not look at my decision. The Constitution says you can remove a judge for being incompetent. The question that I would want to ask you is, in what way or ways can the Judicial Service Commission determine whether a judge is competent or incompetent?
Thank you, my lady. First of all, I'm surprised that I'm being asked that question, because I know it is a very topical question currently, being the question of the extent, the possible extent to which judges or judicial officers could hide behind judicial independence to either hide misconduct or incompetence. And in direct answer to your question, I would almost say you would probably look at the three criteria that were used, that were ordinarily used in matters of judicial review, whether it is so manifestly on its face irrational to a point where you take the view that a reasonable tribunal, a reasonable person, properly trained in law would not come to that conclusion. Parameters that occur to my mind would be, for instance, if a judge were, for instance, a High Court judge and decides to take upon himself or herself a matter that is an ELC matter, then clearly, to me, that is a combination of both possibility of misconduct and incompetence, and that would be an issue. If a judge were to take, say, 5 years to make a decision, that would go into both misconduct and incompetence.
Of course. So after I pointed that, when he was asked that question of incompetence, the only part of the selection that I have had where conflict arises, that is how he answered. Now let's conclude this by saying this. On his appointment as the Supreme Court judge, he meets all the requirements. He's been a judge, he's been an advocate for over 15 years, and of course he meets the requirements under Chapter 6 of the Constitution on leadership and integrity. He has applied, and now, he, just like any other Kenyan, is of course entitled to go to the interview and be grilled for the position of the Supreme Court judge. But reactions are coming out of it. A section of reactions are looking at it as a political move, where people now can stem the 14-year relationship that I started with of Honorable Katwa Kigen to President William Ruto, all the way from the ICC, bring it back to the involvement of Katwa Kigen in this particular, of course, impeachment of governors, then bring it into senior counsel conferment, bring it into Court of Appeal, then quickly escalate it to Supreme Court. And of course, there is something called the Cabranc rule that guides lawyers. A lawyer does not choose a client. So if Katwa Kigen then was fit to handle the issues before the ICC, then you cannot actually sabotage his rise into the position of a Supreme Court judge just based on the previous clients that he has held before. This is what the LSK is about: protection of lawyers' interest, irrespective of what their clients are about. And so the attacks about him really coming from Miguna, coming from Nelson Harvey, coming from Ikuro Court, who are some of the figures that I've seen react on the Kigen issue as one of the shortlisted candidates for the Supreme Court position, is that Kigen is just galloping and applying for any vacant position and should stop. And when you actually listen to all this particular hit being meted against Kigen's possibility of rising to the Supreme Court position, it's just being tied on ethical and moral grounds. He should not do this, he should not do that. None of them, including even Nelson Harvey, who has previously served in the position of Law Society of Kenya and understands really well the Constitution, and the other two gentlemen who are lawyers, that is both Okuro Court and of course Miguna. None of them are actually pointing on a provision of the Constitution and is saying Katwa Kigen should not become the Supreme Court leader because of this provision. They understand that all the provisions of the law do not back Katwa Kigen, but then they have a moral and ethical issue with Katwa Kigen for just being made a Court of Appeal judge, and then just 2 weeks after being made the Court of Appeal judge, going for the Supreme Court judge. Other people feel it's political. They feel like after 2027 elections zimeenda venye zitaenda, of course tutahitaji Supreme Court, na tukifika pale mbele Katwa Kigen akikaa pale and the previous clients of Katwa Kigen ni nani na nani, they are adding the dots and they are saying this could actually be a bigger hand trying to push Katwa Kigen to that position. So you, who is our viewer and has looked at this particular journey of Katwa Kigen, perhaps know him from other litigation or other involvement that are not the ones that we have displayed here, please let us know in the comment section. Do you wish Senior Counsel Kigen the best, the best wishes ahead of his interviews if he gets shortlisted for the interviews of the Supreme Court judge, or do you have your reservations about Honorable Justice Katwa Kigen? And if you have your reservations about Justice Katwa Kigen, who people now are using a lot in the social media space as the individual with audacity actually to get into a job, and just 2 weeks after getting into a job call for promotion, then let us know what is your reservation with the Honorable Justice Katwa Kigen mounting to that particular position of the Supreme Court judge ahead of the 2027 general election. So let us know that in the comment section, ladies and gentlemen. Again, it's been a pleasure recapping for you this story that was actually very close to my heart, because the growth of Katwa Kigen both in the profession and outside the profession is something that is in line with what I do. So I'd really love to know what your thoughts are. If, for example, today I was to represent Joey, the Joey who is now was a convicted criminal then in a murder case, and later on by God's luck and whichever way the Kenyan politics operates, Joey becomes a president, and Joey confers me a senior counsel position, and after Joey confers me that senior counsel position, perhaps I apply for the position, a vacant position in Court of Appeal. I get the vacant position in Court of Appeal, then a vacant position also appears in the Supreme Court, and then I go for that vacant position in the Supreme Court, and Joey is still the president. Would you perhaps admonish me now in that particular position? Would you say I shouldn't get the Supreme Court position because Joey is the guy leading and I represented Joey? Or would you give me that particular position and say, if I represented Joey as a criminal and things went well, then perhaps I have a good mandate to now steer the Supreme Court? You understand where I'm speaking from? And so let me know what you think in the comment section, ladies and gentlemen. Now keep it here, because the second story after this will now be Omwamba, and after that we'll also take a look at now the blow towards Sifuna's camp coming from the section of the ODM leaders who have now made press conference chairpersons to the position of Sifuna as the current Secretary General, and also considering the Linda Mwananchi tour that they have been doing with this cohort. Keep it here, The People's Mirror, your #1 impartial and informative political podcast in Kenya. Until our next episode.